Appeal in the matter of Northumbria and the Commissioners for Majesty Revenue.
Thank you. Good morning, Mr. Firth. You can assume that we have all, I think, read quite widely.
I'm very grateful for that indication, my lady. In terms of my plan, I propose to show you the legislation unless you think that's completely unnecessary. Then I intend to show you the parking principles, which are the key guidance you'll know I rely upon. Then I'm going to establish what I say is the correct test for acting as a public authority by reference to mostly the CJU authorities, and then explain where my respectful submission the Upper Tribunal went wrong. Then I'm going to repeat that exercise for distortion of competition. My aim is to finish around about 3 o'clock with the Court of Commission, obviously.
And we've got a day and a half.
Yes.
And so, Mr. Watkinson, you're happy with that? You'll have sufficient time?
I hope so.
Well,
I will have sufficient time because there'll be a guillotine. So.
Yes, that is how it will be. Lovely. Thank you very much.
I'm grateful. So the legislation is helpfully set out at paragraphs 16 and 17 of the Upper Tribunal's decision. Essentially what you're looking for is a public authority acting as such. That's behind tab 6 in the core bundle.
Thank you. And it was paragraph
16, my lady.
16, thank you. Mm-hmm.
So you can see in the first paragraph, shall not be regarded as taxable persons in respect of activities or transactions in which they engage as public authorities. And then the exception to the exemption from tax in the second paragraph, well, it's a sub-paragraph. However, when they engage in such activities or transactions, they shall be regarded as a taxable person in respect of those activities where their treatment as non-taxable persons would lead to significant distortions of competition.
Mm-hmm.
As the court will know from the skeleton arguments I produced, the essential basis upon which we say the public authority was acting as a public authority is because of the public law duty of adherence combined with the parking principles. And if I may show you those parking principles so that you have them in mind when I come to make my submissions on the law, they're in the supplementary bundle, please, behind tab A6.
Oh, it's all come apart, but 6.
Oh, my apologies.
No, but
Yes, it is tab 6.
6.
Yes. It should be a document with a couple of links and then guidance, NHS patient, visitor and staff car parking principles, 29th of October 2015.
Can I just understand the source of this document? Is it a Department of Health document?
Yes, I believe so.
That's what the label on the front says. And to clarify, you do not pursue any argument based on the contract with the commissioning?
No, we don't rely on the contract because that's a matter of private law for the contracting parties. They can put whatever.
So you rely on the, if you like, direct application, you say, of this guidance issued by the Department of Health.
Yes.
As it applies to bodies such as the appellant.
Yes. The point being that if these principles weren't complied with, an individual affected by that, say a disabled person to whom concessions hadn't been provided, could commence a judicial review saying you should have provided concessions for me as a disabled person, you didn't, and then it'll be up to the administrative court to apply these principles and consider, well, did you have a good reason for not providing those concessions in the usual way that a judicial review occurs? So yes, it's these principles combined with the duty of adherence as referred to in the case law.
It's got a number of footnotes.
Yes.
We don't have the footnotes.
We do.
Do we?
It's not particularly clear, but over the page, my lord, the 1, 2, 3, 4, 5, 6 are the footnotes.
Oh, I see. And you just so we understand the basis of this, these are Department of Health. Have the Department of Health issued them pursuant to some statutory power? It would be quite useful just to understand. I mean, the gist of your argument is these are, as it were, ultimately and broadly in fulfilment of duties of hospitals under the national health legislation, under health legislation. So
Yes,
where do they come from?
I don't rely on any specific statutory basis for these principles, say that they've been issued by the Department of Health to the NHS.
But for what purpose? I mean, why have they issued the guideline? Is it to the tax reasons, or is it for what? I mean, we understand it's by the Department of Health, fine, but what is the basis upon which they're doing it? What are they trying to achieve by issuing these?
Well, they're trying to provide principles that the NHS Trust should follow in relation to the provision of car parking. It's not tax related.
No,
as far as I'm
but therefore
aware,
one assumes it's health related.
Yes, it's to do with the basic functions of how an NHS Trust should go about its activities, and this is one of the sets of principles that the Department of Health has decided they should follow.
Yeah.
I can look into whether there's a specific statutory basis for issuing guidance of this kind, but that's
Well,
not
maybe
something I've relied upon.
Maybe that Mr. Watkinson can actually give us the chapter and verse on this in due course. Interesting. I mean, under the relevant statutory provisions, we've got to know that the body is governed by public law and it's acting as a public authority.
Yes, my lord.
And clearly these are principles disseminated by a government department.
Mm-hmm.
But let's assume it was some civil servant on a whim of his own or her own. That may be one thing. If it's pursuant to a statutory power, there might be another. It might also tell you what the statutory purpose behind the guidelines. The principles, they're not guidelines, they're principles.
Well, I mean, I'll obviously make my submissions on in due course. I mean, there's been no challenge to the proposition that these are principles issued by the Department of Health that
Absolutely.
NHS Trust must follow unless they have good reason to in accordance with the duty of adherence.
And in that regard, on page 154, which is the first page of this document at divider 6, in the penultimate paragraph, it says, details of the charges, concessions and additional charges should be well publicised, including car park entrances, etc. But it says they should also be included on the hospital website and patient letters and forms, which suggests perhaps that that's all part of the health function.
Yes, I mean, ultimately, when you read this, and I will take you through in a moment, you can see what it's trying to do is to ensure that the people who need to use the hospital, be that staff, be that patients, be that family of patients, can do so in a reasonable and safe way. You can get that just by reading in my submission, but the question of whether there's some specific statutory provision that says you may issue guidance in relation to this, I certainly haven't identified one as I stand here now, but I can look at that overnight and see if there's anything that assists there. But my lord, that wouldn't make a difference to my case, because my case is based upon these are the principles issued by the Department of Health.
It might help your case.
Sorry?
You may be right, but it might also help your case. Just
It
to
might.
understand that these do come from a statutory source.
Yes.
I mean, your starting point is they're issued by a statutory by a government department, and they're meant to be complied with. It might buttress your position, in fact, if they have a statutory underpinning.
Yes, my lord. I mean, it'll either be the inherent powers of the Department of Health to issue guidance, or there will be some sort of statutory basis for it. But as I stand here, I can't tell you which of those it is.
Thanks.
In terms of the guidance, the principles set out therein, you can see on page 154 on the bottom right. First point in the second paragraph is charges should be reasonable for the area. Then concessions, including free or reduced charges or caps, should be available for the following groups. And that includes disabled people, frequent outpatient attendees, visitors of relatives who are gravely ill, visitors with relatives who are gravely ill, carers, staff working shifts that mean public transport cannot be used. So for those persons, the guidance says should be available. That contrasts with what we see in the next paragraph, where it says other concessions, for example, volunteers or staff who car share, should be considered locally. So it is drawing a distinction between the things we want you to think about and the things that actually we've decided this should happen.
Can I just, the second paragraph under the first black bold heading, NHS organisations should work with their patients and staff, local authorities and public transport providers to make sure that users can get to the site being the hospital,
Yes.
as opposed to the car park.
Yes, the car park is what enables you to get to the site.
Exactly. So the purpose of this is to enable people to get into the hospital
Exactly.
for a legitimate purpose.
As
health
safely,
related.
conveniently and economically as possible. Yes. And I was just focusing on the contrast between paragraph 3, concessions should be available for the following groups, and paragraph 4, concessions for certain other groups should be considered locally.
Just going back to that first paragraph, first main paragraph, may be relevant also to look at the footnote,
Yes.
which says each site is different and very few will be able to provide spaces for everyone who needs one. That also seems to be
Yes.
potentially relevant.
I mean, that does factor in when you come to distortion of competition. There's not really any excess capacity here. Certainly none's been really identified.
No, and the test is would and significant. So you've got to look at the extent to which there's any capacity over and above that which is naturally used,
Yes.
which could then affect
Yes.
choice between people who just want to park.
Exactly, and in one of the cases I'm going to show you, the point from the Court of Justice was exactly that, which is, well, with or without the exemption from VAT, the same people are going to use this service, so there's no distortion of competition, but I'll come to that momentarily. The 5th paragraph, priority for staff parking should be based on need. Again, we've got a should here rather than a consider locally. For example, staff whose daily duties require them to travel by car. Trust should consider, so this is not a direction, but a requirement to consider, installing pay on exit or similar schemes so you only pay for the time you've actually used. And then in relation to additional charges, they should only be imposed where reasonable and should be waived when overstaying is beyond the driver's control. For example, treatment takes longer than planned, or when staff are required to work beyond their scheduled shift. And when I come to make my submissions on the difference between a private operator and an NHS Trust, these points are crucial, because you park in a private car park operated by a private operator, and you have to overstay because your shift's gone on longer than it should have, or your treatment's overrun. There's no requirement for that car park operator to waive any additional charge. It's very different if it's the NHS Trust car park.
So it's directive, not discretionary. Should is the operative word, I think, on
In this respect, yes.
10 or 11. Almost every time there's an indication of mandatoriness. It should, not could or may or
Yes.
can.
There should consider, so you don't have to, but we think it might be a good idea. And that applies to pay on exit, and you can see why that's a good idea. People don't like paying for 3 hours and then staying for 1.5 hours. But then things that are particularly important, additional charges, should only. There's not really any wiggle room there. I mean, I accept that the public law duty of adherence admits of the possibility you may have a good reason as an NHS Trust for not following that should, but as written, it's a should. Details of charges, concessions, and other additional charges should be well publicised. Should be included on the hospital website, and patient letters and forms where appropriate. And then it says NHS Trust should publish their parking policy, their implementation of the NHS car parking principles, financial information relating to their car parking, and summarised complaint information.
And you might possibly also want to emphasise wherever payment is made inside the hospital. And so you would say, therefore, that shows, perhaps you would say that's an indicator that it shows that that's all ancillary to the health service being provided.
Yes, because the expectation, indeed, what they want is people who need to use the hospital to be able to use this car park.
Do hospital car parks routinely have a statement at the entrance saying this is for users of the hospital?
My lord's testing my knowledge of hospital car parks, I'm afraid I can't answer that question. I can inquire.
I mean, there's no evidence. I mean, my guess is, I see there's
The noise
vigorous
from behind
nodding
is yes.
from behind, but I mean, we don't have evidence of that. But
No, but it's required to be made clear at the car park entrance. So if they weren't doing that, then they should be doing that.
So you say what should be provided at the entrance? There's not something in.
It's the second paragraph from the bottom on page 154. Details of charges, concessions, and additional. Oh, my lord's point was that it's only for users of the
Yes,
hospital.
quite. Yeah.
Oh, right. That I can't offer any evidence on, my lord.
I mean, if there was, I mean, the competition would be asymmetrical. People who use a hospital might use another car park,
Yeah.
but people who want to just go shopping in the high street shouldn't use a hospital car park.
Yes.
And therefore you're dealing with an analysis of competition which starts with the premise that the distortion arises on behalf of people who shouldn't be using it in the first place.
Yes, it's people who shouldn't be using it who are using it.
Yeah.
And there is one example which you've probably seen in the FTT and Upper Tribunal decision of a car park that was being used for people attending a local airport, and they had to increase charges
Yes.
to stop that.
But going back to my lord's point, we don't actually have any findings of fact about the contents of notices and whether it forms part of a typical policy that non-hospital users should not use it. This guidance doesn't say in terms that you must not let
No, but I will show you another
non-hospital
document,
users use it.
if I may. The technical memorandum should be behind tab 9.
Okay, so this is obviously a Department of Health publication.
Yes. And at paragraph 3.5 on page 2. My page number is 232, 3.5. So just to introduce this, maybe it's useful to read paragraph 3.1 because that refers back to the principle.
And interestingly, at 3.6, there's a reference to an appendix which shows car parking charges across the country. And it says NHS organisations should not be implementing tariffs that are not in line with those rates.
Exactly.
So they are being, it's not just a case of what's right in your locality and the competition.
Yes.
It's that you're actually being directed about the level.
Yes, yes. Which feeds into the unsurprising conclusion that hospital car parks are intended for hospital users.
Sorry, just to clarify one small point. We're talking throughout about hospital car parks, but as I understand the decisions, the car parks we're concerned with relate to hospital sites, but also other healthcare
Yes,
sites.
I'm using that as a short
yes, it's a
some sort
short
of health facility.
But to be clear, we're talking about car parks adjacent to healthcare facilities.
Yes, my lady, that's
Okay.
Just coming back, I know we're bombarding you, aren't we? But on page 217, coming back to the point from which the statutory source of this might arise,
Yes.
the third paragraph on the left-hand column, healthcare providers have a duty of care to ensure that appropriate governance arrangements are in place and are managed effectively. And the health technical memorandum provide best practice in relation to this. And this seems to be a memorandum providing advice and guidance on design, installation, operation, etc., of which car parks form one component.
Yes.
So is this guidance to facilitate the exercise of the duty imposed upon a healthcare provider in relation to its governance of its premises?
Yes.
Is that its statutory? Just coming back to the question I asked earlier, that seems to be what this is describing.
Yes, my lord. And the First Tier Tribunal accepted that we're required to facilitate access to our site, which may well include car parking. Yes, it's all directed at ultimately the health service, that people can get to the hospital or health facility they need to get to, park there, not be charged an unreasonable amount, and get concessions where appropriate, and various other things. But it's all directed at facilitating the hospital function. Yes.
And then there's more on.
I was going to say on the same page, or on the right-hand side, second paragraph down.
Yes.
And then there's much more detail on page 226, compliance of the healthcare estate. So car parking is part of the estate.
Yes.
Now, if that's right, I know we haven't got chapter and verse on it, then the principles that you've described are part and parcel of the Department of Health providing directional guidance, because of the should, to enable the healthcare provider, namely the trust, to ensure that its estate is properly managed, one aspect of which is ensuring that car parks can be used properly for those using the service.
Yes.
And I'm sorry to in part repeat what my Lord Justice Green has said, but also to set your homework. But on page 226 in this document, there's reference to the Health and Social Care Act 2008, Regulated Activities Regulations 2010, etc. And further down, there's further reference to that. And it seems as if, for example, paragraph 1.5 on that page, Regulation 12 is saying that it decrees that registered providers must ensure various things, and it seems to me that perhaps that is at least the beginning of the thread that might lead you to the
Yes.
the statutory basis.
Yes, my lady. I've made a note of that. I'm working. We'll report back as soon as it's completed.
And you might want to look at 228, where we've got a lovely, pretty diagram telling us all about it.
I also, although I hesitate again, more homework. 227, of course, refers to the NHS Constitution, and I wonder what the basis of that is and what the direct relevance of it is. It may be.
The NHS Constitution
That's statutory, I think, isn't it?
Yes, it's under the NHS Act. We do have the Constitution. It sets up what you'd expect in terms of the purpose of the hospital being to provide healthcare. We do have that, and that definitely has a statutory basis.
Yeah. Sorry to interrupt.
No, I'm grateful. Right, well, I've made a note of that homework. In terms then of the... So that is my introduction to the principles that I say apply to the provision of hospital car parking. I now propose to move through essentially my supplementary skeleton argument to extract principles from the case law that in my submission will assist this court in deciding what the correct conclusion is, and also illustrating where in my respectful submission of the tribunal went wrong. The first point to consider is paragraph 1, the purpose of the exemption, because as is well stated in the case law, exclusions, well, all aspects of VAT must be interpreted in accordance with their purpose, and that includes exclusions from VAT. And so we need to try and work out what is the purpose of Article 13 when it provides that public authorities are not taxable persons. The purpose is not to exclude non-economic activities for the simple reason that VAT only applies to economic activities, nor is it to try and identify activities considered in the public interest and to exempt them, because first of all, the subject matter of what you're doing is irrelevant, and I'll demonstrate that in the case law later. But also, as the Court of Justice actually noted in its case law, there's a separate provision in the VAT Act that deals with public interest exemptions, and that's Article 132. Could I just briefly show you that, because it does say in terms exemptions in the public interest. That's tab 3 in the authorities bundle, please.
No tabs. Could you give me
I
a
apologise.
page number?
Page 3 in the bottom line, my lady.
Sorry, that's broken. Yes.
And what you can see, this is Article 132 in Chapter 2, which is exemptions for certain activities in the public interest. And then a cursory glance through what is covered includes postal services, medical care, dental care, goods and services closely linked to welfare and social security work. And some of these, are, as you can see in B and, for example, G, are limited to bodies governed by public law. So this is where the VAT legislation deals with exemptions for activities whose subject matter is considered in the public interest, sometimes limiting the exemption to bodies governed by public law. But that's not Article 13. Nor, in my submission, is the purpose of the exemption to identify some sort of core description of what a public authority should be doing and to provide an exclusion from VAT for that. And we can see that by reference to the motorway toll cases, as I've called them. And picking up the France case, which should be hopefully in your third authorities bundle. I apologise if there's no tabs. It's on page 695. These were a series of cases where the Commission challenged various member states for not applying VAT to motorway. And we can see at 26, one of the Commission's arguments. That argument is then rejected at paragraph 41 on page 699.
Paragraph 40, did you say?
41, my lady. Having ruled out there from my submission the possibility that this exception is directed at the particular subject matter being considered beneficial, or this applying to some sort of core conception of what a public authority does, one is left only with the possibility that this exclusion is for the benefit of the public authority itself, and therefore indirectly the public that it serves. And that, my submission, is the purpose.
So the car park is for the benefit of the NHS Trust, which by definition is for the benefit of the public. So it's that causal connection between the commercial activity, the car park, and the public authority, which is critical, which is really what we're looking at.
Yes, but in terms of who this exclusion from VAT is sort of directed at, in my submission, it's not actually the user, because exemptions that are intended to reduce the cost of the user are dealt with, for example, in Article 132. Instead, this exemption is directed at the person providing it, the public authority, and what that may well result in, therefore, and often will result in, is higher turnover for the NHS Trust, or the public authority. Because, just to expand on that, when you look at the cases on the Article 132 exemptions, often you see the Court of Justice saying, well, that's consistent with the purpose of this exemption, which is to reduce the cost of medical care, for example. It doesn't say that in relation to this exemption, and in fact it repeatedly says the subject matter is irrelevant, which suggests in my submission that it's not trying to confer a benefit necessarily on the user directly. Instead, what it's trying to do is confer the benefit on the public authority, which would most often manifest itself in higher turnover, because you charge whatever you charge for your service and you keep all of it.
Yeah.
And that's relevant in my submission, in particular when we come to the distortion of competition point. But just in terms of having my submission on what the purpose of this exemption is at the outset, that's what I say.
Yeah, so in other words, if the trust doesn't, it's exempt from tax but doesn't reduce its prices, but it keeps the revenue up because it wants to buy another scanner,
yeah,
that you would, I mean, that's a possibility which might arise, which does impact upon competition, because if there's no reduction in price, there's no distortion.
yes.
That's the point.
That's my point. That's my point. And my point is that is entirely within the purpose of this exemption.
Yeah.
So when one...
Your point is simply it doesn't have to be used to offset the economic activity which
Yes.
generated the money.
Yes, and in fact, because of the distortion of competition requirement, often it couldn't be. So what is this trying to do? It's presumably trying to get more money for the public, or allow the public authorities to keep everything it can collect, and then use it to pursue its public functions. And yes, the second principle at paragraph 7, so the court will be familiar with the requirements to interpret exceptions from VAT strictly, but that is counterbalanced by the need to ensure that the exclusion is effective and achieves its purpose. And I've set out a quote there from the tax at origin case, which doesn't concern Article 13, it concerned actually Article 132. But in that context, perhaps we turn it up, it's in Bundle 3, the authorities. And at page 779, you can see the commencement of the decision. Page 780, paragraph 3, you can see the provision in question. So in that case, they were concerned with Article 13A. That's now Article 132. The wording of the relevant exemption is the same in F, so 3F. Services supplied by independent groups whose activities are exempt from or are not subject to VAT for the purpose of rendering to their members a service directly necessary for the exercise of their activity. So cost sharing, essentially, where these groups merely claim their members exact reimbursement, and at the end, provided that such exemption is not likely to produce a distortion of competition. I note the difference between would lead to a distortion of competition in Article 13 and not likely to produce a distortion here, and that remains the wording in Article 132. So there is a difference of how one assesses the distortion of competition, which would be relevant if we had the same wording, but we don't. Paragraph 58, please. Bundle's just gone to a different location. So, page 788. The court sets out its findings in relation to the distortion of competition requirement in that particular provision. Could I ask you to read 58 through to 62, please?
There's quite a lot of case law on what's meant by the expression construe strictly. If I remember rightly, it says no more than that the exemption should be confined to its proper purpose.
Yes.
It doesn't mean to say you have to bend over backwards to squeeze something out of an exemption.
Yes.
You just construe it properly by reference to its defined limits.
Yes. And that's what is being said here in my submission, paragraph 62. It's not the purpose that, well, if you've got a more restrictive interpretation, take that one, because thereby you're adopting a strict interpretation. I'm about to show you insurance-wide in the Court of Appeal, which makes exactly my Lord's point. The interesting point here, in addition to that confirmation that you don't just choose a restrictive approach because it's restrictive, is the approach to distortion of competition at 58 and 59, because there the court emphasises that what must cause the distortion is the exclusion from VAT. So in that case, if the distortion was caused, if there was a distortion, if it was caused by the fact that you're a cost-sharing group and only charging at cost, that's not the VAT exemption causing it, that's something else. And then at 59, applying that practically, the court accepted, well, if everyone who's going to use your service with or without VAT is the same, then there's no distortion of competition. Which
Counterfactual is simply to imagine a market in which you didn't pay tax. In other words, where you could theoretically reduce the price by 20%.
Yes.
And you've got to look at the impact, the causal effect upon competition of the possibility that prices might be reduced by up to 20%.
Yes. But even if you did reduce the prices, if the result of that is simply that all the same people who are going to use your service use it anyway, then there's no distortion.
You define your counterfactual, which is up to 20%, and you then ask, would that significantly distort competition? Yes,
exactly. Which is as my Lord says, a counterfactual consideration of what would happen.
Yep.
The point my Lord has just made is illustrated and set out in the insurance-wide case. That's in the first bundle of authority, I'm afraid. And on page 182, and it's paragraph 83, if I ask the court to read that, please.
There's a lot of Court of Justice case law going back into the 70s on that.
Absolutely, yes. And what that means is if, on a fair interpretation of the exemption as interpreted by the Court of Justice, the conditions I'm relying upon satisfy that test, that is sufficient. One doesn't say, well, actually, that'd be very broad. I mean, it isn't that broad, but it's not permissible in my submission to reason, well, that's very broad, therefore we must find a different interpretation. I'll come back to that when I'm dealing with the Upper Tribunal's decision, because that seems to be at least part of their thinking. I'm moving on now to the key test, and that's proposition 3 in my supplementary skeleton, that the only relevant factor is the legal regime applicable to the activity. And
Sorry, could you repeat the only relevant factor?
Is the legal regime applicable to the activity?
Thank you.
And that is the consistent theme throughout over 30 years of case law from the Court of Justice, that the only way you can tell the difference between a public authority acting as such or not is whether the legal conditions under which it acts are the same as a private operator. And we can go right back to near the very beginning, the Carpenetto case. There's two of them. We'll look at the 1989 version first, please. In the authorities bundle, it's bundle 2, please. begins on page 633. This case concerned actually quite a wide variety of activities, including concessions in respect of graves, water supply, public way bridges, and sale of wood. But the Court of Justice gives us a general explanation of what this test is. And if we can begin at paragraph 9, please, on page 638. Could I ask you to read, please, 9 through to 16?
Mm-hmm. Yes.
Well, if I just may make a few observations that the court probably has picked up on anyway. In paragraph 10, we have the confirmation that VAT only applies to economic activities. 12, we have the what will become traditional statement that only 2 conditions must be fulfilled, but it doesn't tell you what the second condition actually means. In 13, it rejects any suggestion that the subject matter is relevant, and it explains in 14 that, well, as I've already referred you to, there is a separate part of the VAT legislation that deals with exemptions based on subject matter, then Article 13A, now Article 132. And at the end of paragraph 50, you therefore get to the decisive point, which is consequently the only criterion. So not one of a multifactorial investigation. The only criterion making it possible to distinguish with certainty between the two is the legal regime. And then in 16, the distinction between acting under the special legal regime on the one hand, or acting under the same legal conditions as those that apply to private traders. That, in my submission, is the distinction being drawn throughout this case law.
Is this where this word special comes from?
This is the first use of that term.
That they're really just saying you've got to identify the legal regime from which this all flows, which comes back to the point we were discussing with you at the outset. Where does this all come from?
Yes.
And we've got guidance, and we've seen there seem to be a penumbra of surrounding legislative duties, powers and obligations. And that's what we've got to look at, and then you just add the word special on top.
And yes, and consider whether it's different to the conditions applying to a private law trader.
Once you've looked at the statutory regime, it's a statement of the be obvious that it's different to the private regime.
It is, but my submissions broaden that in the sense that if all I had was the duty of adherence and the principle, that would be sufficient. Because
yes, I understand.
Yes. The same point is reiterated a year later in the second.
Sorry, just today, it could be the case there's a whole range of of legal obligations on ordinary commercial car parking. But the difference is that if there's another regime which governs whatever the activity is here, car parking, which is different
Yes.
and for a different purpose, then it's that carries the sobriquet special.
Exactly. The same test is repeated a year later in the second Carpenetto decision. I've quoted there at paragraph 10 of my supplemental skeleton. I don't propose to show you the court saying the same thing again. What is interesting, or my submission could be interesting, is the motorway toll cases, because that is where the Commission was attempting to argue that various countries, member states, were breaching EU law by failing to charge VAT on motorway tolls. The Commission lost, and the explicit reason it lost is because it failed to provide evidence that the public authorities were acting under the same conditions as a private trader. So I propose to show you just two out of the collection, if I may. It's the UK case, which is in bundle 2. And at page 725, paragraph 52.
Page 725.
In hopefully bundle. Is that bundle?
It may be bundle
I think
3.
it's the next
Apologise
bundle.
Oh, I'm sorry. So 725, paragraph 52, please.
Yes.
The point I invite the court to take from that is the emphasis on needing to show that the public authority operated under the same conditions as a private trader. That, as we know from Carpenetto, being a key distinction. In this case, and in fact in each of the other cases, the court emphasises that the member state took pains to demonstrate a special legal regime. But the one case where that didn't happen was Netherlands. And if we could proceed, please, to 751, which is the Netherlands case. That's paragraph 37 at the top of the page. We see only the reference to the Commission failing to establish that public authorities were subject to the same conditions. So in my submission, this doesn't take us further than Carpenetto in terms of understanding the law, but it does emphasise where the distinction is drawn. Is it the same legal conditions as a private trader, or is it not? And if it's not, then that's the special legal regime. My fourth proposition, paragraph 13 of my supplemental skeleton argument, is that the subject matter of the activity is irrelevant.
We've already seen that, haven't we?
We've already seen that in Carpenetto. I'm not going to show you it again in Carpenetto. It's been recently reiterated in the Jamina Roclaw case.
Now, Jamina is not part of retained law, is that correct?
It's not, but in terms of evidencing what the court's thinking has been across time, in my submission, it is admissible for that purpose, because there's no change in the law.
Yeah, I'm not saying it's not admissible, I'm
Yes.
just trying to clarify.
Yes, my lady, and that was that's common ground, I believe.
Thank you.
That is bundle 3. And if we could begin, please, on page 933. The context of this case was municipality which owned immovable property and the transformation of usufructs for the users of that land. The transformation occurred by operation of law, but an annual fee was payable to the public authority in respect of the use of the land. The point which I wish to emphasize from this case, if we look at paragraph 78, we see the traditional statement of the test, in particular at the end. And in 79, you have the statement again that the subject matter or purpose of the activity in question is irrelevant. What you don't see in this case, or indeed any of the cases other than the three I'll refer to later, is any reference to some sort of closely linked test. On the facts of that case, just to complete the story, at paragraph 82, the court notes that the public authority wasn't exercising any powers, and at 83, it didn't even have any decision-making powers. It just performed an administrative function of essentially collecting the required fee in relation to the transformation of the usufruct. And so there was nothing there to indicate a special legal regime. I tell you that only so that you know what the answer was in that case. My fifth proposition is that the exclusion is not limited to the core public authority responsibilities. That's at paragraph 15 of my supplementary skeleton argument. I've shown you the raising of that type of argument and its rejection already in the motorway toll case, France, at the very beginning. In my submission, we can essentially get to the same point by considering the first car parking case, which is Fazenda Publica. That, if we could turn to page 773, please, in the authorities bundle. At paragraph 17, you can see the traditional statement of the test. It does not include activities pursued under the same legal conditions. At paragraph 18, we can see what the activity in question there was. It wasn't just off-street parking on land owned by the public authority or on national highways. You can see at the very end, it also included parking on private property or land belonging to private individuals. At 20, the court tells us that whether the public authority owns the land is irrelevant. At 21, we have the requirement to analyse all the conditions laid down by national law for the pursuit of the activity at issue. One of my later propositions is essentially that we must look at all conditions, which would include the duty of adherence plus the guidance. So I just emphasise that now whilst we're looking at it. And at 22, the fact that the pursuit of the activity, such as that initially in the main proceedings, involves the use of public powers, such as authorising or restricting parking on a public highway, or penalising by a fine the exceeding of the authorised parking time, shows that this activity is subject to a public law regime.
That's relevant to the word should. it's because we're talking about powers, not duties. So you can fall within a public law regime and be governed by public law, even if you're exercising a power as opposed to just complying with a mandatory requirement.
Yes, I mean that's one of my key propositions later. Is there's really two ways you can satisfy this test. One, you show you've got rights and powers that are particular to you as a public authority, which you use to carry on the activity, or you're subject to additional obligations and conditions that apply to you as a public authority. This is a powers case. What I'm emphasizing in the context of this proposition, however, is that you can turn the activity of parking on private land owned by a private person into an activity that prima facie falls within exemption simply by a public authority having the power to issue fines. There was no consideration of, well, how closely linked is this to your wider activities as a public authority? Are you doing this to enable access to sort of public authority swimming pools or this, that, and the other? It's just simply no, you're using a public law power to issue these fines. That turns it into a special legal regime. And so it's not concerned with how closely linked this is to any core conception of what public authorities do, which is the point, as I said, you get anyway from the motorway toll cases.
Can I just press you on a little bit on that?
Of course.
In very, very traditional public law terms, you'd apply a Tameside principle to it. In other words, any power must be used for its proper purpose. So there will be a statutory purpose. It may be broad, it may not be, but it's not, the mere existence of a power doesn't mean to say it can be used for anything. There is always some limit on any power in statute.
But that's to do with the content of the power.
Yes, indeed.
Whereas what the court is saying is that once you have that public law power, which admittedly would be subject to those sorts of restrictions by not first to, and you apply it to an activity, in this case, parking on private land not owned by the public authority, put those together and you have got a public authority acting as such. What is missing, what is not carried out, is analysis of, well, how closely linked is that activity of car parking to your wider activities as a public authority? That's just not part of the test in my submission.
If if a public authority used its power for a non-statutory purpose, a non-permitted purpose, I don't think you'd say the same thing, would you?
Well, then that would be outside the scope of the power.
Exactly. So provided it's within the scope of the power,
Yes.
then your proposition you say follows.
Yes. And what I'm going to move to now is my sixth proposition, which shows the other side of that, which is being subject to conditions, sort of, or restriction on purpose, as my lord refers to, and that's the Netherlands 2010 case. So my sixth proposition, as you can see at 17, is that a special legal regime may arise from use of public law rights or powers, on the one hand, or by being subject to public law conditions. The Netherlands case is in bundle 3. It begins on page 823, please. The context is the Commission was challenging an exemption from VAT for the supply of staff in a variety of contexts, but the one we're particularly looking at is in the context of promoting occupational mobility. On page 826, you can see the introduction of the relevant measures by decree entitled Value-Added Tax Supply of Staff. The State Secretary of Finance established the rules applicable to the supply of staff in a number of specific sectors. The decree reads as follows. So these are the rules applicable to the supply of staff in these sectors. Our relevant subparagraph is paragraph 8 on page 829, promotion of occupational mobility. Could I ask you to read the introduction and subparagraph A there of that, please?
Yes.
The key point is that the provision of these staff was subject to that condition you see in A, that they must be available in the context of measures intended to foster occupational mobility aimed at all the workers of the body governed by public law concerned. So this is a purpose condition. It must be for this particular occupational mobility purpose. You can see at paragraph 14 on page 830, right at the bottom, what the dispute was. As I said, it's the Commission saying you shouldn't be exempting from VAT activities, along with a number of other activities. The discussion in relation to occupational mobility begins on page 837, just below paragraph 64. Arguments of the parties. If I could ask you to read, please, paragraph 67, which is the Commission argument, and then 70, which is the Netherlands argument.
'67 and 70.
Yes, please, Madam.
Yes.
The court's assessment begins as relevant at paragraph 81, where it says we're going to consider whether Commission has demonstrated not supplied as a public authority. 82 is the standard test that we come to see a lot. And then could I ask you to read, please, 83 through to 86 to see how the court deals with those circumstances. Key paragraph in my submission is paragraph 86. The special legal regime there was therefore the condition which required the supply to be for the particular purpose of promoting occupational mobility, which demonstrates the other type of case. So you've got the powers cases, the powers and rights cases, and you've also got the conditions cases. This is a conditions case. Just while we're here, could I just show you paragraph 90, which confirms that the aim of the distortion of competition carve-out is that private operators not placed at a disadvantage. That's the very final sentence. It's said in a number of places, but just so you've got. My seventh proposition, in paragraph 22 of my supplemental skeleton, is that the special legal regime must be one that could impact carrying on with the relevant activity. This is a particularly relevant principle because it cuts back what might otherwise be a broader approach to situations where there's a power, yes, but is it or could it actually be used to carry on the activity? And that's demonstrated by the Saudercore case, which begins on page 891, please. And this concerned VAT on activities relating to the planning and management of the health service. We see at paragraph 12 on page 894 what Saudercore's task was. We see at paragraph 15 the Article 10, which gives it powers. The mentioned power is the power of to carry out expropriations. That's relevant because we'll see later that there's doubt as to whether that could actually be used to carry on the activity in question, and therefore whether it was a special legal regime. At paragraph 49, please, on page 899, we see the statement that you should construe Article 13 strictly, because it's an exception. But then at 50, the need to take into account the scheme and purpose of the directive, as well as the place in that directive. 51 is the statement of the two conditions, and then 52 is relevant, I say, when we come to look at whether public law duties such as the duty of adherence combined with guidance can amount to a national law condition, because here the court is emphasising the need for the uniform application of EU law and the principle of equality across member states. So I just ask you to note that now, please. '54 confirms the need for an autonomous and uniform interpretation across the EU. It then moves on to talk about what it means to be a public body in the first place. So the question we're not concerned with, are you a public body at all? But at 70, it goes to the question we are interested in, as to when you're acting as a public authority. So that's page 90170. And we have the same legal conditions as private economic operators test. And that the subject matter is irrelevant. 71 and 72 are, in my submission, very important because they help us understand what the Court of Justice meant in Isle of Wight when it talked about closely linked. So could I ask you to read 71 and 72 together, please? So what the court's asking is there a close link between the activity and, in this case, the powers or rights? And what it means by that in my submission, and I'll make this, well, this is one of my later propositions, is that the activity either does use the rights and powers or could use them. And that's why we see the shift in paragraph 72 into the question of, well, in the case of Saudercore, yes, it has public law powers, the right of expropriation, but actually there's doubt about whether that could be used to carry on its activity of health management, and therefore we doubt whether that overall amounts to a special legal regime for the carrying out of that activity. So my submission is that when it's talking about whether the rights and powers are closely linked to the activity. It's asking no more than whether they are used or could be used. And in Saudicor's case, there was doubt about whether they could be used, in which case there wouldn't be a special legal regime.
The contrast there is the car parking case you took us to earlier, where the power to fine, etc., for overstaying
Yeah,
obviously could be used and no doubt
exactly.
was used.
Exactly. So there's no wider, brand new test introduced in Ireland, and this coming on to my later submissions. All we're doing really is applying, well, slightly extending. You don't actually have to use the power. It's enough that you could use the power. If you, that's what it said in 72.
I do struggle with the word could a bit, because it sounds as though a sort of theoretical use might be enough, whereas surely this is a real world test.
My lady, you must be right about that, and that's my submission later, because when you look at potential competition, the court doesn't just say, well, any theoretical possibility.
Well, we're not looking at the competition limit at the moment.
No, but it's how the court deals with it. It says potential competition, but only where there's a real possibility of it. And the court must mean a real possibility that you could use the power. So, as my lady says, a theoretical possibility you could use a power of expropriation if some ingenious lawyer can sit down and work out a way how an expropriation could support a health and management service wouldn't be enough. It needs to be, as my lady's, well, in my submission, a real, genuine possibility. That question actually doesn't arise here because the conditions I rely on plainly do directly.
I was going to say it doesn't matter here, does it?
Doesn't matter here, no. But it is still necessary to sort of make sure we're not stepping too far from what the court might intend. And that's in fact my submission at paragraph 23, that by parity of reasoning, where conditions are relied upon instead of powers and rights, the question is, well, are they conditions that either do or could, in reality, constrain the activity? And at 24, I make the submission I've just made actually about some sort of likelihood based on a real possibility. So I accept, yes, there must be a real possibility that condition could constrain that activity. And that also explains why the simple duty of adherence by itself doesn't necessarily get you to a special legal regime. If there's no actual guidance that you're required to adhere to, then there's nothing to take you home in terms of the could effect. The theoretical possibility that someone could issue guidance, in my submission, would not be enough. But that's not our case, because we do have the principles. Also, what's not enough, and this has never been disputed by myself, is that mere authorisation by statute is not sufficient. And that's the Commission in Ireland case, as confirmed by both the Upper Tribunal in Chelmsford and the Upper Tribunal in this case. That, incidentally, is the third case that refers to the closely linked test.
If that were not so, then any planning consent would give rise to a claim for VAT recovery, because you'd have a governmental consent to do something.
Yes, the simple fact that you're permitted to do something is not a special legal regime. No. And that is the Commission in Ireland case. There they were trying to argue, well, they hadn't implemented Article 13 properly by providing an exclusion where you weren't acting as a public authority. They tried to say, well, we don't need to, because everything they do is, by definition, under some sort of public law authorization or power. And the court said, no, that's not enough. That's not in dispute. I can show you Ireland if you want, but I don't. My eighth proposition, paragraph 29, is that all conditions under national law are to be taken into account. And I've shown you that already in Fazenda Publica, and you have the reference at paragraph 29, it's paragraph 21. And this is the section where I move into the question of, well, does the source of the obligation matter? Does it matter that the legal obligations here derive from a combination of the duty of adherence plus the guidance? Or does there need to be some sort of statutory basis for the condition? And my submission, as I say at 30, is no, it's the substance of the legal condition, not the fundamental. I start that submission by referring to Saudicor and what I just referred to about the need to interpret EU law consistently across member states and the need for uniform application. And then I move into the Human Rights Act authorities, which explicitly confirm that common law is a matter prescribed by law for the purpose of the Human Rights Act. So at 32, I've set out paragraph 47 of the Sunday Times case. If you want to see it, it's literally just that paragraph, but if you want to see it, it's in bundle 3. At page 960. But I set out the relevant part there, so it's entirely a matter for the court. And it's going to be referred to in the cases we're about to go, which is the Munjaz case and the Hamati case. So if I may move on to the Munjaz case, please. It's in your first authorities bundle. It begins on page 26. But the relevant discussion in my submission begins at page 64.
64.
Yes, my lady. The context was the seclusion of patients detained at Ashworth Hospital under the Mental Health Act, 1983. So pursuant to statute in that case, the Secretary of State had issued a code covering, inter alia, the frequency of medical reviews of seclusion. So that's the Secretary of State's code, which sets out principles in relation to the seclusion and how frequently they should be medically reviewed. The hospital then had its own policy, which was largely based on the Secretary of State's code, but in this respect provided for less frequent medical reviews, and that's where the issue arises. At paragraph 18, we can see that the first question was whether the Ashworth policy was unlawful in domestic law. Could I ask you to just read paragraph 18, please?
Mm-hmm.
And then could I ask you to read paragraphs 20 and 21, please? What I emphasize, if I may, on page 64 by G, there was no express obligation placed on the hospitals to follow the guidance, but nevertheless on paragraph 21, the Lord Bingham sets out that wording that it is not instruction, but it is much more than mere advice which the addressee is free to follow or not as it chooses. It must consider with great care and depart only if it has cogent reasons for doing so. In reviewing any challenge to a departure from the code, the court should scrutinise the reasons given by the hospital the departure with the intensity which the importance and sensitivity requires. The question of whether that amounted to prescription by law is dealt with at paragraph 34, and that's on page 68.
Coming back to the discussion we had at the outset, one of the matters which was relevant to the weight to be attached to the guidance was the place it played in the broader statutory context.
Yes.
You can see that from paragraph 19 and 20.
Yes, I mean, I accept, my lord, that if you've got a statutory basis for saying this guidance may be issued or should be issued, that is a particular factor to be taken into account when applying the duty of adherence, but it doesn't mean that the duty of adherence doesn't apply if there isn't that statutory basis.
Yes.
For the purpose of the Human Rights Act and the ECHR, therefore, that did amount to law, and therefore was prescribed in accordance with law. I note the point about considering different ways in which you could achieve the same or a similar objective, because you could have a regulation or a statute that says hospitals must do this, this, and this, unless they have good reasons for doing so and set out those reasons. And then you would unquestionably have a legal obligation which differs from private operators. My submission is, how can it be different where you get to the exact same legal result, but simply through the duty of adherence plus the guidance? It's just a different way of getting to the same end result in terms of legal conditions. If I could then take you to Lord Hope.
Sorry, just on that, it's interesting the explanation given by Lord Bingham at paragraph 34 about the broad range of institutions, suggesting that circumstances could vary, and
Yes.
hence that was a reason why guidance rather than another method was understandable. You could make a similar point.
Yes, exactly. Lord Hope, who was also in the majority, is at paragraph 91, which is on page 86, please. There, His Lordship says clearly law includes the common law.
Did you say paragraph 91?
91, yes, on page 86, but going over to the page and towards the end of that paragraph, Lord Hope explicitly states, by reference to the Sunday Times, law includes common law. Then if I may ask you to read 94, which is Lord Hope differing from, I think, Lord Brown. Finally, Lord Scott, who was the other member of the majority, paragraph 103 on page 90. Please. key passage, as the court's probably picked up, is the third sentence. It must include also the variety of duties and rights arising out of the circumstances. Before I come to the Supreme Court in Hamati, I just wanted to show you that in an EU law context, the Court of Justice hasn't been concerned with the source of the legal obligation, and that's the E-Frizz case. It's in your third bundle, I'm afraid. It begins on page 815. Context is entirely different to ours. I accept that, of course. You can see it at paragraph 9 on page 817. The directive states that if the consumer exercises his right of renunciation, essentially in relation to a doorstep sale, the legal effects of such renunciation shall be governed by national laws. There's a requirement that renunciation is governed by national laws. This case, as we can see at paragraph 35, concerned a judge-made law. And the Court of Justice upheld that restriction without ever questioning whether that might amount to governed by law or not. And that's at paragraph 50. Incidentally, at the end of this bundle, we have the EU Charter of Fundamental Rights, which contains some similar references to the sort of thing that the Human Rights Act and ECHR concerns in terms of prescribed by law. To just give one example, it's the right to property on page 1006. And my submission is no more than that it is the Court of Justice would, if asked to, adopt the same approach as the European Court of Human Rights in relation to what amounts to law for this purpose. So common law would be sufficient. That's as far as that submission goes. Just to show, across the EU, the source shouldn't matter. I now turn then to the Hamati case, which is in your second bundle, please. It begins on page 525. Context is that EU law, the Dublin III regulations, permitted detention of asylum seekers where there was a significant risk of absconding. That, as we can see at paragraphs 2 and 22, had to be assessed by reference to objective criteria defined by law. So, the first question to be decided. The Court of Justice had previously said in the Al-Chador case, and the Supreme Court begins discussing that in paragraph 26, but if we could go please to paragraph 37 on 538, where there's an extensive quotation from the Court of Justice decision. And in the course of justifying its requirement for that law in this context means binding provisions of general application, we see a subparagraph, so quotation paragraph 43, taking account of the purpose of the provision concerned, and in the light of a high level of protection which follows from their context, only a provision of general application could meet the requirements of clarity, predictability, accessibility, and in particular protection against arbitrariness. What I'm going to emphasise about this decision, which does ultimately decide that the Secretary of State's guidance plus the duty of adherence is not law for this purpose, is the specific context, which is a very particular context concerned with detention of asylum seekers. At 43, we see that the Secretary of State has published a policy in relation to the detention. I'm not going to ask you to read the policy, but just note that there is that policy, because that's what relies upon. At paragraph 50, we see, if I could ask you to read 50 and 51, please. Supreme Court accepts, you can see at the end of 50, that there's no difference in this context between a detention which is unlawful because it's contrary to no statutory power to detain existed, or unlawful because the decision to detain, although authorised, was made in breach of a rule of public law. And what we'll see, therefore, is this case is not directly concerned with how binding or not the guidance was. That's accepted. They're actually concerned with the content. Was it sufficiently certain in terms of the parameters it sets out? So it's accepted that, well, this is something you have to follow in accordance with the duty of adherence. And you can see that at paragraph 55, in fact. If I could ask you to read that next. That sets out the Secretary of State's argument. Supreme Court then moves on to consider whether the guidance constituted a framework of certain predetermined limits at 57, and concludes at 65 that it did not. That's not relevant to our situation. But it then goes on at 66 to consider, in light of the foregoing, it's not strictly necessary to deal with the issue of whether it's law. Nevertheless, since we had argument about it, I will address it. At 68, the Supreme Court acknowledges that Altador was different. The differences being that the framework, the criteria were fragmentary in terms of deciding whether you could be detained or not, and also it appeared that the practice could be altered at will. At 69, you can see the Supreme Court accepted that the Secretary of State's guidance combined with the duty of adherence is different. It had significant legal effects. And can I just ask you to read 69? In my submission, that final sentence really demonstrates the difference a private trader and a public authority are in when there is guidance plus a duty of adherence, because that guidance, combined with the duty of adherence, can be enforced by the individual before the courts. And that must, in my submission, amount to a different legal condition. Paragraph 70 notes the European Court of Human Rights case law I've already referred you to, including the comment that to find that common law wasn't law would strike at the roots of the state's legal system. So that is noted. And then the Munjaz case is referred to. But then at 72, the Supreme Court says, well, we don't accept that based on that, the guidance constitutes law within the meaning of the Dublin regulations, because of the particular meaning the Court of Justice is attached to that, and the particular context of that. And you can see at 73 and 74, it lacks sufficient certainty, essentially. '75 to '79 consider whether guidance plus the duty of adherence could ever be enough. And the Supreme Court sets out arguments against, which it describes as powerful, but then at 79 says, well, we're not going to decide that. Overall, therefore, the duty of adherence plus the code in that case wasn't law, but that, in my submission, was in the very particular context of the Dublin III regulations. And it needs to be understood that the narrower definition of law adopted there, in that context, is for the protection of the individuals. If there's not law, there can't be detention. So by narrowing the scope of law to only things that are sufficiently certain and predictable, we're conferring protection on the individuals. The situation we're looking at is obviously very different, and in particular, the duty of adherence is imposed for the benefit of the individuals. In terms of that, the fact that that is law and can be enforced is for the benefit of the individuals. So a disabled person who believes that a trust has failed in their duty to provide concessions to disabled persons could, relying on the duty of adherence and the principles, go to court and judicially review that. So there's no reason to apply the narrow approach to law which is applied for protection of individuals from being detained in Hamati more broadly. In my submission, the more general approach you see in Munjaz is the appropriate one. And just taking it back then to the test we've seen many, many times in the European Court of Justice case law, are the legal conditions different where you have the duty of adherence plus the guidance? Yes, they are, because they are enforceable by individuals against that public authority. My final proposition before I move on to the Upper Tribunal decision, and I hope to get both of those done before lunch, is the proposition that the closely linked reference is not a new and different test. And that's at paragraph 46 of my supplemental skeleton. And I've already introduced this point to some extent in previous submissions, but I'll make it good. This test, this reference to closely linked, first arises in the Isle of Wight case, which is in your third authorities bundle, please. And it begins on page 792. Ironically, the question of whether this public authority was acting as a public authority was not the question referred. You can see that at 23. Instead, various questions about the distortion of competition limb were asked, but in the course of answering those questions, we find the statement at paragraph 31 of the closely linked aspect.
And this is the first time
This is the
this
first
statement
time.
appears.
It's mentioned in Isle of Wight, Commission in Ireland, and Southall, and no other cases. And you can see 31 says, well, the derogation principally covers activities engaged in by bodies governed by public law, which, while fully economic in nature, are closely linked to the exercise of rights and powers of the public authority. My submission, as the court already knows, is that when it's saying closely linked to the exercise of rights and powers, it is saying no more than the existing case law, which requires that the activity either uses those powers or could use those powers. That's the close link. And I've demonstrated that, or tried to demonstrate that, by reference to Southall, which is the point I make at 48 of my supplemental skeleton. And I've already made the point that, for example, in the Fazenda Publica case, which is a car parking case, there was no consideration of how closely linked is this activity to your broader activities of public authority. And as I said, say at paragraph 53, it doesn't appear in later cases, such as either the Jamina road law cases. But the point to note, the phrasing at 31 is closely linked to exercise of rights and powers. But my key submission on this, as you probably already know, is that rights and powers is one way in which you can have a special legal regime, but conditions that constrain your activity is another. And where it's the latter, you simply transpose the test and say, well, closely linked to the conditions or constraints that you rely upon. And it will be closely linked if either they do restrict it or could restrict it. So it's the same test applied just to the legal regime offered. The error in my submission the Upper Tribunal makes is to take the reference to closely linked to exercise of rights and powers and try and apply that in a conditions case. And what we see, I'll show you this in a moment, is the Upper Tribunal tries to take that and says, well, even if you're relying on conditions, it still must be linked to rights and powers. And that, my submission, is the error. Unless the court has any questions on what I've taken you through in terms of the authorities, I now propose to move to the Upper Tribunal decision. And I think that this is really my original skeleton argument in terms of identifying what I said the errors in the Upper Tribunal decision. And in my submission, there's really 5 errors that you can detect. And the first one first respectful error that I respectfully submit exists is there's a failure to consider both the duty of adherence and the parking principles when assessing whether there's a special legal regime. common theme through the Upper Tribunal's decision on this aspect, which begins at paragraph 47 of the Upper Tribunal decision. That's a core bundle, chapter 6.
Paragraph 40.
47 is where the consideration of this issue begins. It starts by talking about the Edinburgh Telford case and applies and says significantly governed by public law. I'll come back to that. My submission that's an error, but I'm focusing on the Court of Justice case law and the key error. And it's really at 56. They set up my submission, or a version of my submission, but without really the whole of it. And then Mr. Watkinson's reply to that, and then they accept Mr. Watkinson's reply. And you can see that, for example, at 57, what is said against me is, well, it's not sufficient that the public authority is subject to a generic public law obligation to follow guidance. And the Upper Tribunal says at 58, well, we agree with Mr. Watkinson. Ordinary principles of public law will apply to any body governed by public law. Difficult to envisage a body supplying goods or service which would not be subject to at least some public law obligations. If I was correct, then all or almost all activities of public authority would be carried out pursuant to a special legal regime. And they say at 59, my approach is very close to the one rejected in Ireland, that mere authorisation is not sufficient. At 60, the Upper Tribunal says, we see no meaningful distinction in that regard between guidance drawn up by the public body itself and external guidance. The point remains the same. The point is this: the general public law obligation to follow guidance does not amount to a condition laid down by national law for the pursuit of the activity at issue. And my respectful criticism of that is, well, it wasn't just the public law duty of adherence, it was the duty of adherence combined with the principles, which then give you the specific obligations that could be enforced. If an individual goes to court on a judicial review against the NHS Trust, it doesn't just cite the duty of adherence, it combines that with parking law, parking principles to say, you should have offered me a concession unless you had a good reason for not doing so, and in my submission you didn't have a good reason for not doing so. And then it's up to the trust to say, well, we did have good reasons, or if they don't have good reasons, then they're probably going to lose. So what was crucial to my case in the Upper Tribunal in this court is the combined effect in law of those two things, the duty of adherence and the guidance. And you've seen in the Munjaz case and in the Hamati case, the Supreme Court and the House of Lords look at the overall effect of the guidance and the duty of adherence. And they agree. In Hamati, they say, well, it does have significant legal effects. In particular, it can be enforced by an individual in the courts. So it's my respectful submission wrong to simply take the duty of adherence and say, well, is that the special legal regime? No, it applies to in all situations.
Your point is it's the common law overlay on the fact that it's guidance, so that it is justiciable in public law.
Yes.
And the court has said that guidance must be followed absent good reason to the contrary.
Yes.
So it's a combination of both its public law source,
Yes.
and its common law analysis.
Yes. And the common law is the public law aspect of common law. Yes.
And do you have submissions on paragraph 61? Because they're saying you may be able to see a situation where it's closely linked, but they're looking at case law, surprisingly. But the public law principle requiring public bodies to have regard to guidance and to follow it, it said, isn't enough. Nothing in that general principle distinguishes the activity under scrutiny, in this case the provision of car parking facilities, from any other activity. I can see that you've already addressed the principle which is in the middle of that paragraph, but the last sentence I don't quite understand, because the principles are directed at the activity.
Exactly. And that's why my respectful submission is that the error here is to focus too much on the duty of adherence without taking it with the principles and looking at the overall legal effect of the two together. And then when you answer if you take the overall legal effect of the two together and you try to answer that question, we say, well, it clearly is different, because here, in relation to this parking, you have these various obligations, unless you can show a good reason for not doing these various things. And so it quite clearly is different to both the other activities of a public authority, which aren't subject to those principles, and, more importantly, the activities of a private law trader, who certainly isn't subject to these.
And what do you say also about in the last line? It seems as if it's linked in the UT's mind also with rights and powers, the other side of your coin, if I might put it that way.
Yeah, so that, I was going to come back to that at the end, but I can certainly address you on that.
No,
now.
don't let me take you out of
Well, no, it's helpful because actually you see what is said earlier in the tribunal decision is carried through here. And it's not quite clear exactly what the upper tribunal is saying, but it might, on one reading, be saying, well, not only do you need conditions that are different, but you also need to show those conditions are closely linked to the exercise of rights and powers, which, for reasons you've already heard, I submit is the wrong test. And if we go back to 29.5, please. So that's on page, so paragraph 29 is on page 7 of the decision, where the upper tribunal sets out certain principles. So it says, at the end of the paragraph, we gratefully adopt the following propositions from the Chancery decision with some expansion on our part. And the fifth proposition is the activity must involve or be closely linked to the exercise of rights and powers of the public authority. And it cites two decisions. One is the Isle of Wight, which does say that, and I've already shown you. Facenda Publica does not say that. Paragraph 22 of Facenda Publica is simply where the Court of Justice says, in this case, you have the power to authorise parking on highways, and you have the power to issue fines, and therefore that's a public law regime, or a special legal regime. So that, in my respectful submission, that error, that's 29.5, is the failure to realise there could be two things it's closely linked to, either conditions or the rights and powers. By only focusing on one aspect of that, the tribunal ends up having to say, well, yes, well, even if you did have conditions, they're not closely linked to your rights and powers, and therefore you fail the overall test. And that's, for the reasons I've already submitted, an error. You can see that again at paragraph 38. So if the court were to agree with me on the correct interpretation of what the closely linked reference is trying to get at, then it would logically follow that this is an error, because it could be closely linked to the rights and powers, or it could be closely linked to the conditions and constraints relied upon.
What over being required to act in accordance with the statutory power would you need for something to be closely linked on this analysis? And if you're required to act in accordance with the statutory power, according to paragraph 38, that's not enough. There's got to be something more. What are they contemplating is the more?
I think it's the use of the rights and powers, like you see in the Facenda case, that was the use of the power to issue fines, whereas in Saudicor, it was the absence of any possible use of the power of expropriation to carry on a service of health management. So in the rights and powers case, you need to ask, well, okay, you say you've got these rights. It's not enough to be authorised. That sort of goes without saying. You've got to have rights and powers that you could use or do use to carry on the activity. And that was the difference between Facenda, where they were used, and Saudicor, where it was doubted whether they could be used.
In this case, we're not talking about rights and powers. We're talking about restrictions.
Exactly.
So the principles upon which NHS trusts have to work are largely focused upon price, which is the very essence of competition. So there's a whole series of restrictions about price, concessions, caps, reasonableness, absence of incentives, all those sorts of things, which go to, those are a whole series of restrictions, which are quite limiting, quite curtailing, wouldn't be applicable to a normal commercial operator who has freedom over price, freedom to exploit, you name it.
And so
But why doesn't that make it even closely linked? You're being denied, even on this test, you're being denied the ability to do something which a normal car park operator would be entitled to do.
because I think the Upper Tribunal, referring to rights and powers, is sort of saying it must be closely linked to your rights and powers as a public authority.
But a paradigm case of somewhere where you might think an exemption would apply is when somebody's subject to restrictions, not
which is why my submission is, well, you translate this test into a conditions case by simply asking, if you need to ask anything to do with closely linked, is it closely linked to the conditions? And the best example of a conditions case is the Netherlands case, which was the staff hiring out staff for occupational mobility reasons. And in that case, there's absolutely no mention of rights and powers because it's not relevant, because you're relying on conditions and restrictions. So that's why I say, respectfully, the Upper Tribunal errs here.
The essential test in the statute is just governed by public law, acting as a public authority, and that covers a multitude of different ways in which you are so acting.
Yes. Yes.
I mean, it's a broad brush approach, governed by or as.
Yes.
It doesn't tell you whether you're exercising a power or subject to a restriction. Those are just merely illustrations of either as or governed by.
Yes, and my submission was and is, it shouldn't be surprising if public authorities often do act as public authorities. So that if the result of the test is that most activities of a public authority are them acting as a public authority, that's not a surprising conclusion. I mean, that's not the way I get to my conclusion, but I'm just saying it's not a surprising result. That was actually my fifth error, which was an incorrect understanding of what the Court of Justice intended by its reference to closely linked. Whilst we're here, could I just, in the course of the discussion of Edinburgh Telford, the tribunal says that the conclusion in that case, paragraph 52 of the Upper Tribunal decision, its conclusion was thus based on a finding that the activity of the college was governed to a significant extent by public law, and says that's consistent with the position that's emerged from the jurisprudence of the Court of Justice that requires it to involve or is closely linked to the exercise of rights and powers of public authority. In my respectful submission, we don't get that test out of the Court of Justice case law. There's no reference to significant extent. What you have is, as I've said, the requirement that either you've got rights and powers or conditions, and they could or are used or constrained. My second error is I respectfully submit that the Upper Tribunal erred both in how broad it thought the result would be and whether that meant it should adopt a narrow approach. As I've already shown you, the key theme of 57, 58, 59 is, well, if I'm right in what I say, and as I've already submitted, they're not quite right about what I do say, but if I'm right, then it's so broad that you're not going to be left with much that isn't covered by a public law regime. For the reasons I've already given, it should be obvious that my submission is not as broad as that, because it's not the duty of adherence per se, it's the combined effect. I won't belabor that point again. And when you take those together, the scope is reduced. You can't just say, well, we've got a duty of adherence, therefore it's a public law activity. No. Is there actually guidance? Does it actually constrain you?
You might add to that guidance which constrains you specifically in this respect.
Yes.
So, for example, a local authority would have a general duty to act reasonably. You're not, as I understand it, submitting that something like that would be enough.
No.
The guidance in this case has an actual
Yeah.
impact.
That's the point. I accept that the mere duty to act rationally, when the alternative is to act irrationally, doesn't in any real sense constrain you, because you'd be expected to act rationally anyway. We've gone well beyond that, as my lady says, with specific requirements that you must specifically follow unless you have and can articulate good reasons which will be scrutinised by the court.
Yes, I mean, to be clear, if there was no guidance,
Yeah.
a private operator could in principle act irrationally. There would be a
Yes.
distinction.
Yes. But not.
You don't need to.
That
go
sounds
that far.
theoretical, but
Yeah.
which is the sort of thing the court rejects. But I don't need to go that far. I certainly don't go that far. I don't even need to go as far as saying that guidance issued by the authority itself would be enough. I mean, that you've read what's said in Munjaz and Hamati. That's an interesting question, and it's notable that the Supreme Court said in Al Jador that one of the relevant aspects of that case was that it appeared the practice was alterable at will. And you can therefore see that, well, if the only guidance relied on is guidance you've issued, which you can change when you want to, does that really constrain your activity? I can see that might well not amount to something that does constrain your activity. But that's not our case. And therefore we do have externally issued principles that we must follow, and we can't change them when we want to. And that's why when you see it at 60, the Upper Tribunal says we see no meaningful distinction in that regard between guidance drawn up by the public body itself and external guidance. But in fact, that's not right. There is clearly a difference.
In terms of their durability, I was noticing from the House of Commons report that you've included in the bundle that these principles go back to, I think, at least 2006.
Yes.
I think that first laid down the principle that income generation activities must not interfere to a significant degree with the provision of NHS core services.
Yes.
They must be profitable. The profit must be used to improve health services.
Yes.
So that's the enduring
Yeah.
limitation, which then translates into the more precise principles.
Yes. Returning then to my second error in the Upper Tribunal decision. So the first aspect of it was it's not as broad as the Upper Tribunal says. The second aspect is that it's not correct to start from the proposition that if it's broad, we must therefore reject it. For all the reasons I've given, that you don't adopt an interpretation simply because it happens to narrow it. You still have to consider the purpose and the reason for this exclusion, and whether what you have before you satisfies that. And if you do have a public authority that's subject to legal conditions which are different to a private trader, then you've satisfied what the Court of Justice is trying to get at. How broad that happens to be for a particular member state or a particular authority shouldn't then lead you to reject an interpretation, simply to narrow it. That's, in my respectful submission, not the right way to go about this. So that's the second point. The third point was the failure to consider whether the appellant was engaged in car parking under the same legal conditions as a private operator. And it's telling in my submission that nowhere does the Upper Tribunal say, in terms you, the trust, operate under the same legal conditions as a private operator. Because how could it? And we know, going right back to Carpimento, feels a long time ago now, that's the only criterion by which you can distinguish whether you're acting as a public authority or not. And yet the Upper Tribunal doesn't actually, in terms, apply that test. It takes the duty of adherence and sort of misses out the key part about combining it with the principles. The final error, because I've already dealt with my fifth one, so this is point 4, but it's actually the fifth one I've referred to, is the erroneous conclusion that the duty of adherence does not amount to a condition laid down by national law. That's at paragraph 60. I submit, so in the second sentence, the point remains the same, that the general public law obligation to follow guidance does not amount to a condition laid down by national law to pursue the activity at issue. And my submission is the one I've already made, that, well, law includes the broad range of legal obligations. That's not what the right place to be sort of questioning this. The right place is the question is, well, does it actually impact the activity? So it is law. That much is, I submit, clear from the various considerations of that. The key question is, well, does it constrain the activity? And that's where you would introduce your concerns about, well, if it's just a general duty to act rationally, does that actually impact the way you carry it on? Probably not, because private traders are logically, they don't have to, but they're logically going to behave rationally anyway.
I mean, it may not be relevant. They behave rationally in an entirely different way. They're profit maximising.
Yes.
Whereas rationality in a public law sense is to pursue a proper purpose, a statutory purpose.
Yes.
But I mean, it does raise the question how far back you go before the distinction becomes so blurred that it doesn't exist.
That's why you need something tangible that you can say, well, it's that differentiates you. For example, so if we've got the principles, so I don't actually need to go any further back than that. But I mean, well, the Netherlands case is a good example, because there the staff had to be hired out for the purpose of promoting occupational mobility. And you can imagine a power to do something under UK law, which is for a particular purpose, and we know under public law you have to exercise the power for the purpose it was given. So based on Netherlands, that would be, if there was an identifiable purpose, that would be your special legal regime. But we don't need to go any further back than that and start worrying about is rationality by itself enough, because that's not our case. And that is the 5 errors I respectfully submit the Upper Tribunal made. And once you correct those errors, the conclusion ought to be, in my submission, that there is a special legal regime because we don't act under the same legal conditions as a private operator. Unless the court has any questions on the acting as a public authority aspect, I'm going to move now, if I may, to introducing the cases and principles on significant distortion of competition. At 55, I make a preliminary point, just so the court has it in mind, that it was agreed, there was common ground in the Upper Tribunal, the burden of proof on this issue rests with HMRC to show that non-taxation would lead significant distortions of competition. And part of the reason for that, if you go back to the Isle of Wight Special Commissioner's decision in 2006, paragraph 21, is the difficulty a person faces in proving a negative. So having to prove that although no distortion of competition, well, you have to rule out every possible theoretical possibility of distortion of competition. So that's why the burden of proof is on HMRC to say, well, this is what we submit would be the distortion of competition. Then the tribunal can assess whether they've made out their case on that. And I also emphasize as a preliminary matter the importance of this issue beyond this immediate appeal. There are not only a number of NHS trusts waiting to see what the outcome of this case is in relation to various issues, and therefore what they would need to prove in relation to distortion of competition. But also for public authorities generally. I mean, if we end up with an interpretation of Article 13 and the UK implementation of that is practically impossible, or is impossible to satisfy in practice, then that's very significant. So public authorities need to know what they have to do to avoid falling foul of this distortion of competition point, not just in this case and the cases I'm looking at it, but public authorities in any case that might rely on Article 13. My first proposition is at paragraph 56 of my supplemental skeleton argument, which is the test must be applied and evaluated by reference to the activity at a national level, rather than by reference to each local market in which the activity occurs. And we can see that, so these are the questions that were referred in Isle of Wight.
So that's in Isle of Wight.
Yeah, it is. But I think it is relevant to look at exactly what the court said, because my submission is that the Upper Tribunal's approach essentially makes this exercise entirely abstract. Whereas, although the Court of Justice definitely said don't look at local markets, my submission it wasn't saying don't look at any real markets. And therefore, that there is potential for this to be important in your consideration of the Tribunal decision.
But the concept of would give rise to a significant distortion has to be viewed in the context of a market. And it would be very, very odd if you won this case and you didn't have to pay tax, but somebody in the West Country or in the south of England lost the case on the facts because the market was slightly different.
Yes.
Or the configuration of car parks were different, more city centre than out of town.
My Lord,
they did have to pay tax.
My Lord's exactly right, and that's the reason why the Court of Justice rejected a local market, because that's what it was asked, is it a local market test? And rejected that because then you could have different answers in different parts of the countries, and you could have even more difficulty because local authorities' sort of areas of operation could overlap, and that was off-road parking, so it could apply across the whole geographical area of a local authority. And it said, no, we can't be doing with these possible distinctions where not only have you got a difference in treatment between a private operator and a public authority, you might have a difference in treatment excuse me, between one public authority and another. And it just rejected that, saying that's completely unworkable, that's not what we're going to do, and that's why it's referenced by reference to the activity in question in my submission in the member state in question.
Or the market over which tax is applied, or the area over which
yes.
the tax is applied.
Yes.
And you could conceivably, or you wouldn't under devolution have difference between England and Wales, but if tax is applied uniformly across both jurisdictions,
yes.
You're trying to decide whether tax should be applied or not.
Yes, yes. And so I absolutely accept we're not looking at a specific local market, but we are looking at the market, an actual market, at a sort of an overall level. I don't know if you need me to show you what the Court of Justice said about that. It sounds like the court's already got those points firmly in mind, and I basically just said them. It's paragraphs, I'll give you the paragraph references. It's 46, 49, and 53.
46, 49 and 53.
Yes, my lady.
And that's in Isle of Wight at authorities?
It's bundle 3. In fact, maybe we just turn it up because the next principle actually comes from Isle of Wight as well. It's bundle 3, page 792.
792.
Yes, ma'am. Paragraph 45, in fact, if you see what the local authorities were arguing for. 790. can see
Yes, they
that.
put it in the context of fiscal neutrality. And that's why, in a sense, you logically, I mean, it almost certainly will be a national market.
Yes.
But that's one of the reasons, is because that's where competition applies, because the fiscal regime affects all those operating on the market in that way.
Yes. 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 So that's why, yes, you don't look at the local markets. But I just note in 46, the second line from bottom, it says the sole strain of that principle concerns the relationship between the bodies and the private operators. So you're sort of looking on the one hand the public authorities, that's one part of it, on the other private operators, and together that's your market, the two together. But there is a strain, is what I emphasise. There is still a strain on this principle. We can't just decide this by abstract reasoning in the way that, in my submission, the first tier tribunal and the upper tribunal do. And that logically applies.
So you say it's national and practical. That's the essence.
Yes, my lord. And my submission is that this applies not only to the question of whether there is competition, but whether competition will be distorted. You don't sort of look at, well, that particular hospital had some people from an airport using it, and therefore we've got a significant distortion of competition. I mean, obviously we know in that example they changed their prices, but an isolated example like that wouldn't show you that at the national level you've got a significant distortion of competition.
And it's in a nutshell at 53.
Yes, my lady. My 10th principle, and maybe the last one I'll deal with before lunch, if the court's permission, is simply the fact that competition includes potential competition, provided the possibility of a private operator. Entering the market is real.
I mean, that's trite as a matter of competition law. I mean,
Yes.
if there were, take an absurd example, 10 HS hospitals in a region, all of whom had enormous car parks, and they all decided not to charge, then that would deter new entry into that area.
Exactly.
That's potential competition that can't get into the area.
Exactly. Exactly.
That's a huge effect on competition.
Exactly. So if that was what happened, then, well,
It's relevant, that's all it's saying.
exactly. And the point I make, well, as well as just simply accepting that, my lord's point, and it being tried not only in competition aspect, but in relation to this, is at 64, it goes back to my lady's question earlier about, well, could the condition affect the way you carry on the activity and theoretical possibility. I simply note at paragraph 64, the court's rejection of theoretical possibilities of someone entering the market, which is consistent with a broader approach that, of course, the Court of Justice is concerned with real possibilities. The EU law, VAT is concerned with real possibilities rather than theoretical. I don't propose to start my 11th proposition because it's the biggest one, and I've got 5 minutes, so I don't think I'll get very far. So unless the court has any...
And you're doing quite well, Mr. Falk.
I think I am, yes.
Yes.
I'll definitely be finished by 3, I think.
Okay, we'll rise until 2 o'clock. Thank you.
Court rise. What's it? No, we can have a quick chat because it's still live streaming, so I'm going to pop outside of a quick chat. I'll just look over all of them, so that's afternoon.
I know.